Hello and welcome to another Analysis Behind the News, where we provide the perspective that you can use to help save American liberty and independence. So last week, U.S. Representative Rashida Tlaib announced that she would be introducing an impeachment resolution to start the impeachment proceedings. You probably recognize her as the classy Democratic Congresswoman from Michigan who announced at a Move On reception that she was going to impeach the expletive from office. Her profanity-laced rant was caught on camera, and she now plans to follow through by introducing this resolution sometime this month. So we thought we'd spend a little bit of time looking into the topic of impeachment. First of all, what is it? According to the online version of Black's Law Dictionary, impeachment is a criminal proceeding against a public officer before a quasi-political court instituted by a written accusation, end quote. This written accusation is called articles of impeachment. The Founding Fathers placed impeachment as a tool within the U.S. Constitution. Many think that impeachment is reserved for trying the office of the president only. However, Article 2, Section 4 of the Constitution states, "The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors." Again, turning to the online version of Black's Law Dictionary, they define civil officers as all officers of the United States who hold their appointments under the national government, whether their duties are executive or judicial, in the highest or the lowest departments of the government, with the exception of the officers of the Army and Navy. End quote. For any officer to be impeached, articles of impeachment must be first brought up by the House of Representatives, which has been specified by the Constitution as having the sole power to do so. The accusation comes from the House, which begins as a resolution and is treated as a bill would be. A committee would take it up, have hearings, and the majority of the House must pass it. Once this happens in the House, an officer is considered impeached, and the articles of impeachment then go over to the Senate for a trial. Until there is a trial in the Senate, the office holder remains in office. Now back to the Constitution. It says here, "The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present." One interesting note about that clause, did you catch it? It does not state that 2/3 of the Senate is needed to pass. It says that 2/3 of the Senate members that are present are needed to pass. That way, individual members of the Senate cannot stonewall the proceedings by not attending. If those present in the Senate hit 2/3, then the officer is removed. The Constitution states, "Judgment in cases of impeachment shall not extend further than to removal from office and disqualifications to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law." Plus, the Constitution holds the bar rather high for bringing up impeachment proceedings, including conviction of treason, bribery, and other high crimes and misdemeanors. While we can understand what treason and bribery entail, high crimes and misdemeanors is something that's a little ambivalent. So we turn to constitutional attorney Joel Wolverton, who shed some light on this phrase in an online article at thenewamerican.com. He wrote, "As with so many key terms contained in the Constitution, high crimes and misdemeanors was not defined because it didn't need to be. If your employer told you that you'd be fired if you took a day off in the summer, you wouldn't go looking in the employee handbook for a definition of the word summer. So here's a brief rehearsal of the universal understanding of high crimes and misdemeanors provided by the Constitutional Rights Foundation." They write, "The convention, Constitutional Convention, adopted high crimes and misdemeanors with little discussion. Most of the framers knew the phrase well. Since 1386, the English Parliament had used high crimes and misdemeanors as one of the grounds to impeach officials of the Crown. Officials accused of high crimes and misdemeanors were accused of offenses as varied as misappropriating government funds, appointing unfit subordinates, not prosecuting cases, not spending money allocated by Parliament, promoting themselves ahead of more deserving candidates, threatening a grand jury, disobeying an order from Parliament, arresting a man to keep him from running for Parliament, losing a ship by neglecting to moor it, helping suppress petitions to the king to call a Parliament, granting warrants without cause, and bribery. Some of these charges were crimes, others were not. The one common denominator in all these accusations was that the official had somehow abused the power of his office and was unfit to serve." Mr. Wolverton concludes further into his article with, "As laid out in the history above, the critical question is not so much which acts qualify as high crimes or misdemeanors. The most important inquiry is whether the president is suspected of abusing the trust placed in him by the people and whether that abuse injures the people or the Constitution that binds them in a union. The answer to that question can only be determined by the people acting through their elected representatives in the House of Representatives and the Senate, who must be candidates committed to protecting the public from tyranny, protecting the Constitution from tyrants, and impeaching anyone from President to Supreme Court Justice who threatens the liberties of the people or the Constitution written to protect those liberties." Now, according to the House of Representatives, 19 officers have been impeached in the last 230-some years, including 2 U.S. presidents, Andrew Johnson in 1868 and Bill Clinton in 1998. Both presidents were acquitted, meaning that the U.S. Senate did not have enough votes to convict. In President Johnson's case, he escaped conviction by only 1 vote. And an interesting side note is that the John Birch Society had greatly pushed for the impeachment of 2 officials over the years, including U.S. Chief Justice of the Supreme Court Earl Warren and President Clinton. The project to impeach Chief Justice Warren was a lesson to the American people that we should not let the court get away with legislating from the bench, that the court does not create law, and that it renders opinions that only bind the plaintiff and or the defendant. We were not successful in getting the House to bring up articles of impeachment. However, we certainly were in the case of President Clinton. He was impeached, but the Senate did not have enough votes to convict. And regarding the Clinton case, the Washington Post wrote this on December 15th, 1998. As recently as a year ago, they were far out on the fringes of politics. A small band of conservatives convinced that Bill Clinton is so corrupt and venal that he ought to be impeached. But a group once viewed warily, even on the right, helped launch a groundswell of Republican support for impeaching a president for the first time in 120 years. These early impeachment activists range from Robert L. Bartley, editorial page editor of the Wall Street Journal, to Representative Robert L. Barr Jr., one of Clinton's strongest critics on the House Judicial Committee, to the leaders of the John Birch Society, an organization hearkening back to the anti-communist 1950s. So even though the bar is set high, impeachment can certainly occur, even in the deep state. And this brings us back to the Constitution. Impeachment is a tool that needs to be wielded not for political purposes, but in terms of protecting the public from tyranny. It is a tool that specifically should be utilized more often for those civil officers serving in the national government, including congressmen, senators, judges, and even presidents. Along with impeachment are various other tools that can be used to help protect the public from tyranny, including interposition and nullification. Put briefly, these tools empower officials to stand up to overreach by other local, state, federal, or international government officials or agencies that are operating where they have no constitutional authority to do so. Now, we estimate that if our Constitution were obeyed and adhered to, the federal government would be slashed by 80% its size and 80% its cost. If that interests you, we suggest that you join the John Birch Society today to become part of a national concerted action program that is putting big government back into its place. And to find out even more about these tools that are available to Americans to rein in government, pick up a copy of our Article 6 Solution Booklet. Links are available in the video description, so please act today and then like and share this video with others. Until next time, we'll see you then.